This is a short, crisp, concise, exam oriented, edited editorial for civil services aspirants. In this podcast, we are going to talk about plea for contempt action. Source for the content is the Indian Express. Attorney General of India K.K. Venugopal has declined a request for consent to initiate criminal contempt of court proceedings against senior advocate and Member of Parliament Kapil Sibal for certain remarks that he made during a speech on the subject of judicial rollback of civil liberties. The AG or the Attorney General said in his opinion, rejecting the request made by Advocate Vineet Jindal, and I quote him here, "No part of the statements cast any blame or aspersion upon the court." Unquote. Now, what is contempt of court and why is the consent of the AG required to proceed in a matter of alleged contempt? Now, around the world, contempt of court or simply contempt is understood as a set of legal provisions that firewall courts and safeguard and protect their ability to dispense justice. The Cornell Law School's Legal Information Institute defines contempt as the disobedience of an order of a court and also conduct tending to obstruct or interfere with the orderly administration of justice. It is also understood to describe acts of defiance or disrespect of court orders or judges and to ascribe motives to them. According to the Contempt of Courts Act 1971, contempt of court can either be civil contempt or criminal contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court or willful breach of an undertaking given to a court. Criminal contempt, on the other hand, is attracted by the publication of any matter or the doing of any other act whatsoever which, number one, scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, or number two, prejudices or interferes or tends to interfere with the due course of any judicial proceeding, or number three, interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. Now, who can bring a charge of criminal contempt of court against an individual? The Contempt of Court Act 1971 lays down the law on contempt of court. Section 15 of the legislation describes the procedure on how a case for contempt of court can be initiated. In the case of the Supreme Court, the Attorney General or the Solicitor General, and in case of high courts, the Advocate General, may bring in a motion before the court for initiating a case of criminal contempt. However, the motion can be brought by a private citizen as well, and in such a case, the consent of the Attorney General or the Advocate General, as the case may be, is required. The motion or reference made for initiating the case will have to specify the contempt of which the person charged is alleged to be guilty. But what is the reason that the consent of the AG is required? The objective behind requiring the consent of the AG before taking cognizance of a complaint is to save the time of the court. Now, what is the reason that the consent of the AG is required? The objective behind requiring the consent of the AG before taking cognizance of a complaint is to save the time of the court. Judicial time is squandered if frivolous petitions are made and the court is the first forum for bringing them in. The AG's consent is meant to be a safeguard against frivolous petitions, as it is deemed that the AG, as an officer of the court, will independently ascertain whether the complaint is indeed valid. Now, what if a court itself decides to bring a case of contempt? It can indeed, and it did so recently in the case of Prashant Bhushan. In such a situation, the AG's consent is not required. This is because the court is exercising its inherent powers under the Constitution to punish for contempt, and such constitutional powers cannot be restricted because the AG declined to grant consent. A three-judge bench headed by Justice Arun Mishra, now retired, reiterated this position in the Prashant Bhushan case. The court had said, and I quote, "As far as the suo motu petitions are concerned, there is no requirement for taking consent of anybody, including the learned Attorney General, because the court is exercising its inherent powers to issue a notice for contempt. It is equally well settled that once the court takes cognizance, the matter is purely between the court and the contemner. The only requirement is that the procedure followed is required to be just and fair and in accordance with the principles of natural justice." Unquote. AG Venugopal had repeatedly objected to the court's initiation of contempt proceedings against Bhushan during the course of the hearing, but the court had gone ahead anyway. And what happens if the AG denies consent in the case of a private citizen? If the AG denies consent, the matter all but ends. The law also has a limitation period of 1 year for bringing in action against an individual. The complainant can, however, separately bring the issue to the notice of the court and urge the court to take suo motu cognizance, that is, on its own motion cognizance. If the court does take suo motu cognizance, as it did in the case of Prashant Bhushan, the consent of the senior most law officer is not required. Article 129 of the Constitution gives the Supreme Court the power to initiate contempt cases on its own, independent of the motion brought before it by the AG or with the consent of the AG. Article 129 states that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Now, finally, what is the process if the AG does grant consent? Once the AG gives his consent in writing, a notice under the Contempt of Courts Act is served personally on the person against whom the proceedings are sought to be initiated by the court. If the court decides not to serve the notice personally, the law requires the court to record the reasons for it. If the court is satisfied that the alleged contemner is likely to abscond or evade judicial proceedings, it can order attachment of property of a value that it deems reasonable. Once the notice is served, the alleged contemner may file an affidavit in support of his defense, explaining the nature and circumstances of her remarks. The case is required under the Act to be heard by a bench of at least two judges. The court then takes into account any evidence available to check the affidavit and pass appropriate orders. That's it for this podcast. Thank you so much for listening. To join KSG India courses and to crack the IAS exam, visit ksgindia.com. You can also get a PDF of this podcast on ksgindia.com. Thanks for listening and do subscribe to our channel.